In the United States, courts and juries were designed to protect liberty, serving as vital checks on government power. These institutions were the Founding Fathers' answer to centuries of tyranny, a shield against corruption, and a sword for justice. Yet, as the system evolves, questions arise. Are these institutions still fulfilling their purpose, or have they strayed from the vision of our nation's architects today? We will examine the historical foundations, modern challenges, and the enduring importance of courts and juries in safeguarding freedom. Together, let's uncover how we can restore confidence in the judiciary and uphold the rights endowed to us by God and protected by the Constitution.
These people stood up for their rights and were killed for it. How is that right? What sort of country do we live in when we're giving these unalienable rights and you're breaking them?
A lot of people think that they all held hands and sang Kumbaya. These were men that were fighting just like we are right now. But the fact is that these men needed to make sure that the future generations understood what was at stake and continued to fight for it.
Any elected official who is spewing out the word democracy instead of constitutional republic is not honoring their oath. So the Founding Fathers created sovereignty because sovereignty can't be given to us by man. We've gotten our sovereignty from the Lord, and they wrote the Constitution based on what they knew God expected from them.
The Founding Fathers, again, back in pre-1776, there were many instances where the British had arrested people without warrants, seized property, gone into their house, had actual soldiers living in some of their homes, arrested people and put them in the public square with no evidence other than administrative enforcement, and all these abuses of people's rights. And they were all part of the list of indictments in the Declaration of Independence.
So the Founding Fathers established our country because they already knew unsuccessful governments. So they were trying to create something that had never been created before.
When the Founding Fathers signed the Declaration of Independence, I believe their intent was to create a nation where God is above all and no law is above man.
And when you look at the Declaration of Independence, the 27 grievances, they even discuss the importance of being judged by a jury of peers in the local area where the crime occurred. And again, the founders didn't create that system. They were there to preserve it. Because remember the Declaration of Independence, very, very obviously very unique, where first and foremost, it recognized that our rights come from God. They don't come from man, they don't come from the government, they don't come from a piece of paper. Our rights come from God. We have natural, unalienable, God-given rights. And then it says, and to secure these rights, governments are instituted among men. That's the proper role of government. That's the reason why government was created. It was to protect our rights. It's to secure these rights. Which rights are God-given rights? But then the next line says, deriving their just powers from the consent of the governed. That's where the government gets their power. Their just powers, justice. That's what justice is supposed to be about. They get their power from our consent. How? How and when do we give our consent?
It was such a different time. Religion and God was above all, obviously. And you can see from all their writings, the nation was founded under God.
I believe it was a check and balance on the check and balance, or within the check and balance, in that it gave both the grand jury first the principles to look at that had been supposedly defined as a crime or an offense, and determined whether they saw merit in the prosecution of someone's expression so under. If not, then the jury at trial gave the final expression of check and balance to this. I believe that our forefathers looked to see more fall through the cracks in indifference and not be prosecuted than I did to have all prosecuted. Nobody goes through the cracks. I think many were defined, as it said, guilty, beyond a shadow of a doubt. Not just guilty by someone's opinion, but guilty where it could not be challenged. That was what originally they had intended, and the jury had the duty to check prosecution against a citizen for those very qualities. The judicial was created so that that was kept in check, always against a push over into it. The jury, the grand jury and the jury gave us check and balance, the jury being the final check to the expression of a law, even if it was so read and so correct, but violated if there was a perspective given within the actions of that citizen. It was the jury's duty to look upon it and say, well, I don't blame you.
In the United States, courts and juries were designed to protect liberty, serving as vital checks on government power. These institutions were the Founding Fathers' answer to centuries of tyranny, a shield against corruption, and a sword for justice. Yet as the system evolves, questions arise. Are these institutions still fulfilling their purpose, or have they strayed from the vision of our nation's architects?
The problem with all of these type of things, law written or law expressed, is that each time we turn a page in tightening down the definition of a law, we actually limit our own expression in any field that would be related to it. The perspective of division and oversight was a check and balance that our forefathers placed. This was judicial, legislative, and executive. It's a simple perspective. If you have highest authority, that's leading authority. But if you have 5 adults, then it's perspective that you have oversight one to another, that they don't trample on the existence of the other.
I think in Title III there was one expression of a grand jury, but trial by jury and all these particular rights were not there. That's why a number of states would not ratify the Constitution. 9 did, and that's all that was required to start to establish the Constitution. And the first thing that the Congress did by those 9 states was to write a Bill of Rights, which included all of the protections of trial by jury. Trial by jury, whether it was a grand jury prior to an indictment being, or prosecution, or it was a trial of actual, whether civil or criminal, in an actual trial situation. These were all added into the Bill of Rights and declared as part of the original Constitution. To get the other 4 votes, they needed to get all 13 colonies to go ahead and ratify the Constitution. These things were added later. Grand juries, particularly, were put in there to stop what had happened and what they witnessed pre-Revolutionary War. Government couldn't just go out and arrest somebody, couldn't just come into your house and start searching for things to arrest you for.
Somewhere along the way, it appears the courts have mutated into a system of oppression. What was meant to protect civilians of these great United States has become something else entirely. It has morphed into a mechanism that, if not returned to, its original intent will continue to be an ever-increasing burden on the American people and a tool for the powerful and unjust to hurt the very ones our Founding Fathers drafted it to protect.
You know, when I think of the justice system, I think of it as a process. It's an institution that is charged with meting out, with surfacing and determining, yes, what are the facts of the case? What is the truth? But most importantly, I think it's a process where we're supposed to be based on justice. That's what is just, what is morally right and wrong. But unfortunately, I think we've come to the point where we don't have a justice system anymore. We have a legal system, which is entirely different. A legal system is more about the rules and codified regulations and code and statute versus any sense of right and wrong. And I think that that's happened because of our disrespect and disregard for the seriousness and the opportunity to be the voice of the community with the jury system.
There are major players at funding Democrats and Republicans at the same time. I have a saying that I've grown fond of. It's the left wing and the right wing belong to the same bird, and that bird is a buzzard.
What I think that their problem was is they believed that it would stay that way, and people would fight for their own freedoms and their own liberties, and did not expect that people would become so complacent.
So when people say that the courts are one of the biggest banks in the world, what it means is they're open every day and they're collecting money every day. I mean, it's a racket. You go in there, you get an attorney fee, you get a court cost, and it's built to generate money. That's all it is. Don't get me wrong, do I agree with court systems? Yeah, I do, because not everyone's perfect. You've got to have some sort of system that punishes people that step out of line. You can't have people running around with an axe killing people and there's no court system to put them away. I understand that, but it has to change the way it's set up. It has to change in the fundamentals.
There was a decline in public trust in the jury system for a couple reasons. Number one, jury trials are very rare anymore. It seems that people are pleading out and they never get the chance to exercise their jury rights. The trial just never exists. The second part of it is people feel that the juries are tainted. I think the example in the indictment in the Trump case in New York. People outside of New York look at that and say, how is this possible? This is bias,
Now today, we hear about jury nullification and jury instructions and all these judges, and they don't like this idea of juries thinking on their own.
What we have today is a skewed expression, if you would, of separation. We have mostly everything under executive, and the legislative and the judicial are very much withered on the vine.
They're not there because they're the most impartial or anything else. It's who funds them, and then who can essentially trick the populace into voting for them.
The judge tells them you can't do this, this, and that. They give them instructions to the jury, and it takes the judge a day and a half to read it.
Maybe he had ruled that, okay, something that was presented isn't admissible, so erase that from your minds. You can't do that as a human being. You're going to always remember if they tell you a fact about something that's a damning fact, especially, it's going to be right there in the forefront of your minds. But we can pretend that they don't remember this.
The major challenges facing a pettit jury today is the very fact that they're not getting the opportunity to exercise their power. They are being, in fact, every effort is being made to emasculate and usurp their power in the process of maintaining the laws that are passed by our legislators.
I had dinner a number of years ago with an attorney, and we got to talking about the jury system, and he said, we've got to get rid of the jury system. I was shocked. I was like, what do you mean? Are you serious? And his whole point was, well, the law is so complex that it's really hard for the average American to get caught up to speed, to understand the intricacies of the law, to be able to apply it. And I was thinking, isn't that the whole point? Isn't that the whole point where we, the people, giving our consent in the jury box, whether or not we're going to be held to account for such a law that if it's so complex, how are we supposed to follow it?
People not experiencing jury trials, not understanding them, and number two, when they do see them, they see that they're handcuffed.
We actually started getting into these lawsuits and witnessing judges that had black and white law, U.S. code in their face, the Constitution, especially with the religious accommodation lawsuits. And they would find anything they could to render it moot, not the right venue, whatever, just name the reason, they could find it. And I think it all goes back to that money, like who funds, what's their agenda.
Section 5. The judiciary's role within the separation of powers was intended to reinforce public trust. As independence weakens, skepticism grows, challenging the integrity of the justice system. This erosion raises questions about the system's capacity to uphold fairness.
The courts today do not follow the citizens' right. They want to see everybody as guilty, and the federal court pretty much does, because you're dealing with rules and regulations. So if you violate the rule in the way you express yourself, that's supposedly a crime, although there's no criminal intent or a violation of a law that has been broken.
I have no love for attorneys. I've got attorneys. Everyone has to have attorneys. It's an evil that we have to have, because attorneys make all the rules. And whether you like it or not, they do. Trust me, a divorce case for a man and a woman, they know each other. How much has he got? How much can he give her? How much can we squeeze out of it? Don't tell me that doesn't go on. I know it goes on. I'm sick of it. I'm sick of attorneys thinking that they sit above us, which they don't, by the way. And always remember, you pay their invoice, they don't pay yours, so therefore they work for you.
Today, they throw the word conspiracy on top of anything and create it as a violation. This is marched back before the grand jury after the indictment of information, and the grand jury just puts the rubber stamp on it, and that's what happens. So what we have, the judicial then would have been the normal court of order, and that would have had a continuing oversight, and did for many years. But in 1948, the court systems were exchanged, in a sense, in this country, in that we lost a constitutional background, and we went to an administrative court, which was rules and regulations. This came from admiralty law, or Article I law, and the United States District Court is an expression of that form of law, not Article III, which would be constitutional. So the separation of powers was fragmented, and in doing so, it became a sole expression of the executive branch, because what is the executive branch but the administration of admiralty, and that is the law of military.
People are just missing that opportunity to make a statement to their legislators who pass the laws, and therefore they don't get a chance to express it. To be honest though, in today's level of education of our citizenry, I think a lot of it is well beyond them. It's something that needs to be addressed immediately in our schools and in society in general, and it's something that should be talked about quite a bit, because it's very important.
So what we end up with is exemplified, if you would, in the recent trials and hearings that were brought up against Trump. In one, the grand jury had not yet indicted, yet the charges of indictment were released, and they were leaked. And then the grand jury indicted, and he was served.
Well, the grand jury was originally designed to protect the general citizenry from an overzealous prosecutor, from someone who, you better do what I say or you're going to jail. If you didn't do anything wrong, why are you going to jail? But if they have that kind of force and power, then there had to be a mechanism that would be established to prevent them from being that arbitrary and abusive. So the grand jury was set up where a grand jury of citizens would sit there, and prosecutor would go to them with evidence or petition or them with regard to an indictment, proposed indictment, and lay out the case before them. And if they got 50% or better, then the prosecutor was given permission.
Amid these challenges, the enduring legacy of courts and juries offers hope. Through education and civic responsibility, citizens can restore the system to its original vision, ensuring justice and liberty for future generations. There are many instances in modern lawfare that prove the intent of our judicial system is being manipulated and used as a device for control and bankrupting those who descend from the modern status quo.
All throughout history, they refer to the grand jury as a sword and a shield. Now, it's a shield because of the indictment process, where the government wants to charge someone with a crime, but it's a grand jury that steps in and says, hey, wait a minute, before you charge them with a crime, you need to go through us first. We're going to protect against wrongful accusation. We'll take a look at the facts that you have, the evidence that you have. We'll take a look at the law. We'll judge the application of the law, what you really want to charge them with, and we'll make the determination first. That's why it's a shield. Now, it's a sword because they can actually initiate investigations on their own initiative to determine whether or not there's corruption going on. And there's so many cases throughout history where this has been pivotal and of utmost importance, where we, the people, the voice of the community, in a body of peers, a body of local people, can actually reach inside the government and root out corruption.
It is the actual core check and balance that we have over all the governments. And once you start expressing the importance of that to people in education, in civics class, and this and that, I think people will gladly look at their duty as, hey, I want to exercise my duty. I want to make sure that society and is being protected and the law is being applied in an unbiased, fair way.
Modern challenges strain trust in courts and juries. Grand juries, originally safeguards against overreach, now face criticism for lack of transparency. Addressing these flaws requires confronting the system's vulnerabilities and reaffirming its foundational purpose.
Our founding fathers always were looking to preserve and protect the expression of an individual. So the grand jury was always set forth as a protective tool. However, today the perspectives are skewed greatly, and the intent of the grand jury today is to get you into court in a formality that looks constitutional, but is the perversion of what was a constitutional protection.
You know, when it comes to the grand jury, you know, what do we really think about? What do we know about the grand jury here on the outside? Really, we don't know a lot about that institution. It's a lot of secrecy. And, you know, we see in the news, so-and-so was indicted today, and they portray it as if, they act as if someone is guilty of something, but that's not the grand jury's job. When it comes to an indictment, it's where the government wants to charge someone with a crime, but it's a grand jury that is a buffer or referee between the government and the people. And I'm using that phrase on purpose because that's what Scalia said in 1992 in a Supreme Court case where he wrote the majority opinion. He referred to the grand jury as a buffer or referee between the government and the people. That's where a body of peers step in and say, hey, hang on a minute, government. You want to charge one of our citizens here, our local citizens, with a crime. We want to take a look at that first. Do you have enough evidence to actually charge this person?
A grand jury today will indict a bologna sandwich. And this is said many, many, many times because they have no perspective of the law, its refinement, its restrictions against government's expression, or the citizens' rights thereunder.
I got to, for disclosure purposes, I must say, in my whole life, I don't know one person who's ever been asked to be on a grand jury.
Yeah, my entire life, I don't know anyone who's been called into a grand jury.
I don't know anyone who has ever been called to serve on a grand jury.
Fifth Amendment says no person shall be held to answer for a capital or otherwise infamous crime unless by a presentment or indictment of a grand jury. It doesn't say presentment, indictment, or information. It doesn't say that.
It's very interesting when you go to court and you're going to go for jury duty. When you go for jury duty, you get a nice little piece of paper and it tells you what time you need to show up. And it is very serious. You get the summons, you are told when to show up, you're told exactly when to call. There's protocols for every single little item. 3
out of the 10 Bill of Rights include reference to the jury system. Petite juries for criminal cases as well as for civil cases. So it was very important to them.
Most of the time today, the jury's instructed to view it from the perspective of only the violation of the rule, not whether it should be applied or not, or it's fair to be applied. And that's an instruction given to them a lot of times by the judge or the proceeding officers, which is improper.
I have sat in a courtroom as a court reporter and listened to a judge Multiple judges give jury instructions. He tells them how to apply the law to the case. He tells them what they cannot consider in evidence, even though that they've just heard the evidence. As a court reporter for 20 years, I sat in on many jury selections, and I can tell you that I've been called to jury duty one time. The moment I opened my mouth about being a court reporter and understanding just a little bit about the law, I was immediately cut. But I can tell you that you start off with a room full of people, and you have a prosecutor and you have a defense attorney, and they're trying to whittle you down to the least educated, lowest information juror possible. If they think you have an inkling of the law and how to apply it to whatever they're there to defend, they're going to get cut.
Amid these challenges, the enduring legacy of courts and juries offers hope. Through education and civic responsibility, citizens can restore the system to its original vision, ensuring justice and liberty for future generations. There are many instances in modern lawfare that prove the intent of our judicial system is being manipulated and used as a device for control and bankrupting those who descend from the modern status quo.
We got to get the attorneys need to come away from the way they're set up. Got to go back to common law. And I think if you change that, things will change.
The Constitution is written in a way to give us the power, not for us to be lazy.
We can restore confidence by educating people how important that the jury system is to maintaining their liberties.
This Constitution it's almost 250 years old, and we are a constitutional republic. And as long as we are able to educate other people, go back, dig deep.
So it's vitally important to keep our nation. The Founding Fathers had the perfect document written as long as the people it was written for understood it and lived by it.
It's far more important to understand the foundation for which you are even going to school, what you're trying to accomplish. If you lose your constitutional rights, if you lose your nation, your degree will be worthless.
You need to look at everything extremely objectively. You need to follow the money. This isn't a short-term fix, it's a long-term fix. It's a marathon, and we're all eager to fix it.
So again, it always comes back to money. You know, fundamentally, everything is about money. It's about power and money. And I've said to numerous people that money's not bad. Money, you need money. You need money to survive, you need money to barter, you need money to buy things. Money's good. It's the love and the lust.
We the people and the Constitution and the grace of God.
Courts and juries have always stood at the crossroads of vigilance and responsibility, serving as the cornerstones of justice and liberty. The Constitution, a living testament to these ideals, guides generations in the pursuit of freedom. By revisiting the system's foundations and addressing its flaws, we can ensure these guardians of liberty endure. The path forward demands education, engagement, and unwavering commitment.